Welcome to the Property Elite podcast. I'll be your host, Jen Lemen, chartered surveyor and co-founder of Property Elite. Stay tuned each week for more on industry hot topics, market updates and new RICS guidance.
Alienation is a key lease clause that you may come across in commercial leases. It is relevant to a number of commercial real estate competencies, including leasing and letting, purchase and sale, landlord and tenant, and property management. An alienation clause will provide the right to transfer the leasehold interest in a property to another party. Without an alienation clause written into the lease, the interest cannot be transferred, so it is essential that it is considered at the initial heads of terms and lease drafting stage. The flexibility and extent of an alienation clause can affect a variety of matters, including future use and occupancy of the property by the tenant, capital value for the landlord, and control of who occupies the property by the landlord. While landlords can also assign their leasehold interest, we will primarily focus on the rights of tenants in this article. Alienation clauses provide for a variety of rights, including the right to assign, to sublet or to underlet, both terms mean the same thing, and to share possession of a property. At level 3, you need to consider why you might advise a client to assign or sublet their lease. This could be due to a requirement of the lease, for example, assignment of whole is permitted, but assignment of part and subletting of whole or part are prohibited, or because of the requirement to dispose of only part of whole of the demise. Subletting, if permitted, may be preferable if there is a profit rent, for example, the difference between head lease rent and sublease rent, although leases often require that the sublease rent must align to the head lease rent to avoid this situation arising. Subletting may also be advisable if the intermediate tenant may want to take back possession and reoccupy the property in the future. Key considerations. If you're advising on applications from a tenant to assign or sublet in relation to the property management competency, you will need to consider the following. What rights does the tenant have? Ensure you read the lease carefully. Will the tenant give an undertaking for the surveyor's costs and legal costs? What is the proposed rent and what does the lease say about what this must be? What will be the impact on capital/investment value for the landlord? This could be influenced by the ingoing tenant's covenant strength. Have you checked the tenant's accounts and credit reference? What does the lease say in terms of granting consent and documenting this by way of a formal licence? Are there any reasonable grounds for withholding consent that must be considered? What security might be required, such as rent deposit or authority's guarantee agreement? You also need to be aware of the Landlord and Tenant Covenants Act 1995 relating to assignments only. This became effective relating to leases dated 1st of January 1996, and it is not retroactive, i.e. it does not apply to leases granted before this date, some of which may still be in force. For old leases, agreed before the 1st of January 1996, an original tenant who assigned a lease as well as subsequent tenants and guarantors remain liable under the lease until expiry. For new leases, agreed after the 1st of January 1996, privity of contract was abolished so the former tenant was released from all liabilities under the lease following assignment. This meant that a former tenant could not be pursued for rent arrears, for example relating to a lease assigned many years ago. An authorised guarantee agreement can be required by a landlord where reasonable. This is an agreement between the landlord and the most recent assignor to guarantee the lease obligations of the immediate assignee. This falls away on future assignments, so the original or subsequent assigners could not be held liable for future liabilities indefinitely. Reading up on the provisions of sections 17 to 20 of the 1995 Act is recommended if you're advising clients on privity of contracts and assignments. Best practice. The RICS Professional Standard Code for Leasing Business Premises, first edition, provides mandatory and best practice guidance on agreeing alienation provisions in new leases. Leases should allow tenants to assign the whole of the premises with the landlord's consent, which is not to be unreasonably withheld or delayed. The guidance provides further clarity on more specific alienation requirements and provisions, which you should read. Being aware of different forms of alienation and being able to advise on their agreement, interpretation and implementation is an essential skill for a chartered surveyor involved in this area of practice. It is recommended that you refer back to the APC series article, How to Summarise a Lease for a Rent Review, to practice your skills in interpreting alienation clauses before considering the impacts on your client and how you should best advise them.
Thanks for listening to the Property Elite podcast this week. Head to our website to check out our full blog, free and paid support resources and services, free consultation for every single RICS APC and ASOC RICS candidate, and also ask us any questions you have via the website chat blog. See you next week.